Hello, everyone. My name is Sean. I am the Crypto Smith. I do appreciate you guys clicking on this video. We're going to talk a little bit about the SEC versus Ripple case, but it's really not just about that. It's about the Lbry versus SEC case and how today's hearing could impact that case. There was some good news based on the secondary sales of a token. So if you don't know, the SEC sued Lbry, the Lbry token, essentially saying the exact same thing. What Ripple did, that they sold illegal or had a illegal security offering in the beginning, sold those tokens, and they shouldn't have done that. It should have been registered as a security. Lbry says no, that's not the case. Whatever. All right, it went through the courts. The judge sided with the SEC. The SEC won. Right, it was a good win for them. Not so good win for Lbry because it's basically they're going to go out of business. But now today's hearing was what they call a remedies hearing. And you can see Jeremy Hogan here on Twitter today says, today is the remedies hearing, the SEC versus Lbry case. The SEC wants the judge to issue a broad, vague injunction against the sale of the Lbry token in which the token itself becomes the security. Now, the remedies hearing basically comes down to what are the fines going to be? Like, what is the punishment going to be for Lbry? Fines, injunction possible, and disgorgement, which is basically a fine based on any kind of profits that they may have made on the sale of those illegal securities. So today's hearing, John Deaton, who is representing a Lbry token holder, wanted to be there to make sure that the sales in the secondary market for the token were not going to be held up, right? That those weren't going to be considered a security. So, and obviously that has a relationship to the SEC versus Ripple case, when all they really want is clarity on the XRP token is not a security going forward. Even Brad Garlinghouse and their team have said they'll take a settlement as long as they get that specific clarity. So this, because it's come before the disposition of the Ripple case, this precedent here, whatever is said here, is going to be brought up by either the Ripple team or the SEC. And the SEC has already brought up the fact that the judge ruled in their favor. They brought that up at least, I don't know, I think they said like 20 times in the final motions that were filed, so the judge can go and determine, what she wants to do, what kind of decisions she's going to make. So this is definitely going to be impactful one way or the other. Now, what we got was good news from John Deaton. He was there. He got to speak to the judge about clarity for secondary sales. And it turns out that it looks like it's a good thing. The judge actually did get the SEC to state that secondary sales or sales on secondary market are not securities. That's not what they were going after. So now, just because they said that on record, now the judge still has to go back and write out his final version. And he's basically, it sounded like he was going to give him a fairly insignificant fine. He also stated that he wasn't really inclined to approve the injunction. So that's a win also. So if the judge in his final ruling lays out all the details about the punishments, right, that are happening because of this case, if he states in there anywhere that the initial sales were illegal securities offering and secondary sales going forward do not constitute a security, that's really what we want to see. That's going to be able to help the Ripple versus SEC case. And so with that, I'm going to include some of the video that John Deaton put out after he was done with the hearing to show you basically, his firsthand account on what actually happened. So bear with me. I'll show some video clips here and you can listen and kind of see what I saw.
When the judge and I are going back and forth, the judge then explained to me that he's not inclined to give an injunction. And so that's out the window. There's a great victory there. There's not going to be an injunction that can be applied to users like Naomi or anyone else. But then I said to him, Judge, great. You're not going to give an injunction, but you still please have to address this secondary market issue. And I pointed out to him that there's so much confusion about it. And then he did something great. He basically looks over at the SEC and says, you agree, right, with him that, imagine that. I want everybody to imagine that a judge looking over at the SEC attorney saying, you agree with Deaton, right? They weren't that happy about it. But they then said, well, what if it is a particular agent of the person? And then it could be, and the judge said, you got to make a commitment. And the judge did something great. He said, let's use an example. And he said, Lbry sold to an investment club who took the LBC and put it in cold storage, a direct sell. The judge said, I found that to be an unregistered securities offering. And you agree with me, right, SEC? And they go, yes. Then the judge said, but if Flipside sells it to someone else in the secondary market, independent of Lbry, you got to agree that that's not, my order doesn't apply to that scenario. And that's the victory that we got. The SEC had to concede that on the record in real time. So call that what you want, but that was great.
Okay, so that was, I mean, it's good news, right? I mean, this is positive for the Ripple versus SEC case. It gives us something to look forward to. Obviously, Ripple and the Ripple team, they're going to be including some of this information once it comes out, formally. Then they'll be able to give it to the judge as well and try to use that to their benefit. So that's it. That's really all I had for you today. I hope you guys have a great night, and we'll see you guys next time.